Thank you very much, Mr. Chairman. Mr. Professor Snapper, let me start with you. Thinking about the arguments that you made in both the Gonzalez case and then also in the Twitter case recently. In both of those cases, just to make sure that folks who are listening understand it, you were arguing on behalf of victims' families that were challenging the tech companies. Have I got that basically?
Yes, sir.
So the court, of course, is deliberating on these cases. We don't know exactly what they're going to do. We'll have to wait to find out. But in both of these cases, help us understand your argument and set the scene for us. You were arguing that there is a difference. These tech companies have moved beyond merely hosting user-generated content to affirmatively recommending and promoting user-generated content. Is that right?
That's correct.
So explain to us the significance of that. What's the difference between claiming immunity from not just hosting user-generated content, but now claiming immunity from promoting and affirmatively recommending and pushing user-generated content?
Well, I think that's a distinction that derives from the wording of the statute. The statute seeks to distinguish between conduct of a website itself and materials that were simply created by others. And that distinction's clear on the face of the statute, and the legislative history. Representative Lofgren at one point said holding internet companies responsible for defamatory material would be like holding the mailman, those were the language we used at the time, responsible for delivering a plain brown envelope. What's happening today is far afield from merely delivering plain brown envelopes. Internet companies are promoting this material, and they're doing it to make money. At the end of the day, social media companies make money by selling advertisements. The longer someone is online, the more advertisements they sell, and they have developed an extraordinarily effective and sophisticated system of algorithms to promote material and keep people online. And it sweeps up cat videos, and it sweeps up terrorist materials, and it sweeps in depictions of tragically underweight young women with dreadful consequences. So that's the distinction we were drawing.
Tell us, you mentioned algorithms, and I think this is so important. Tell us why you think these algorithms, which didn't generate themselves. The algorithms are designed by humans. They're designed by the companies. In fact, the companies regard them as very proprietary information. I mean, they protect them with their lives. They're the essence of their companies, their business model in many cases. Tell us what legal difference under Section 230 you think these algorithms and algorithmic promotion makes in these kind of cases. Why is that such a key factor?
Well, the algorithms are the method by which the companies achieve their goal of trying to interest a viewer in a particular video or text or whatever. And it's done in a variety of ways. It's done with autoplay, so that you turn on one video and you start to see a series of others that you never asked for. It's done through little advertisements. They're known as thumbnails, which appear on a YouTube page. It's done with feed in newsfeed, where Facebook, in the hopes of keeping you online more, proffers to you materials which they think you'll be interested in.
So let me just ask you this. Does anything in the text of Section 230, as it was originally written, suggest, in your view, that platforms ought to get this really form of super immunity for taking other people's content, hosting it, promoting it, and in promoting it, making money off of it? I mean, does the statute immunize them from that? Does anything in the text support this super immunity in that way?
I spent a very long hour and a quarter trying to answer that question a few weeks ago. We think the text does draw that distinction, and that brings back so many happy memories that you ask that. So yes, that's our view, but we're not here to retry the case. But that is our view of the meaning of the statute. But it would be entirely appropriate for the committee to clarify that.
Let me just get to that point and finish my first round of questions with that. If Congress acts on this issue, what would be your recommendations for the best way to address this problem from a policy legislative perspective? The problem you've identified in these cases about affirmative recommendations, how should we change the statute, reform the statute to address this problem?
I'd prefer not to try to frame legislative proposal as I sit here. It's complicated. And I'd be happy to work with your staff and my colleagues here, all of them, on that for you. But I think it would be inappropriate for me to start tossing out language as I sit here.
Thanks, Professor Schnapper. Thanks, Senator Hawley.